All right, so buckle up, everyone, because today we are diving deep into the world of Indian finance law.
Sounds exciting.
Right. Specifically, we're looking at the Insolvency and Bankruptcy Code.
The IBC.
Yeah, the IBC for short. Now, I know what you're thinking. Finance law, that's not really my thing. But hold on. This stuff actually impacts how businesses get the money they need, and that affects all of us, right?
Absolutely. This is essentially the rule book for when things go south, financially speaking, for businesses in India.
Exactly. And today, we've got some fascinating sources to pick apart. There's this academic paper that really digs deep into the IBC. And get this, some recent case laws that are going to make your jaw drop.
Oh, I love a good legal drama.
Who doesn't? So we're zeroing in on this idea of related parties within the IBC. Basically, when a company's about to go belly up, the IBC wants to make sure that close buddies of that company don't swoop in and unfairly benefit from the situation.
Right. It's about protecting the integrity of the process. The IBC is designed to protect those creditors who lent money in good faith, preventing any funny business from insiders trying to game the system.
Exactly. A level playing field,
Yeah.
But here's where things get really interesting. This paper we're looking at points out that the IBC's definition of a related party is so broad that it could actually end up snaring lenders who are just trying to be cautious with their investments.
Ah, so you're saying that by trying to be responsible, lenders might accidentally get caught in the crossfire.
Exactly. They're not trying to be puppet masters, just careful investors, right?
Right, and it's totally standard practice for lenders to negotiate certain rights when they give out loans, especially with borrowers who are considered high risk. They want some safeguards in place.
Sure, makes sense. You don't hand over a pile of cash without some assurances, right?
Exactly. It's about making sure their money is being used responsibly. Think about things like appointing a director to the company's board or having veto power over major decisions.
Right, it's like having a watchdog in the room, making sure the company isn't being reckless.
Exactly. But, and this is a big but, these standard protections that lenders often put in place, the IBC could misinterpret those as evidence that the lender is actually a related party. And that's where things get messy.
Okay, now you've piqued my interest. How does that work? How could being a responsible lender backfire in this way?
So imagine this. You're a lender, you did your due diligence, you put those standard protections in place, but the company you lent to still goes belly up, right?
Ouch, not ideal.
Not at all. Now, if you're classified as a related party under the IBC because of those protections, you could actually lose your voting rights within the Committee of Creditors.
The Committee of Creditors, they're the ones who make the big decisions about the company's future, right?
Exactly. The Committee, for short. They decide things like how much the creditors will get back, if anything at all.
So let me get this straight. They're trying to be responsible, protect their investment, and it could come back to bite them if the company goes under. That seems counterproductive.
It's a real catch-22, and it highlights a major tension within the IBC. This academic paper we're looking at, it doesn't just talk about this in theory, it actually cites some recent court cases where this exact issue has played out. Real-world examples of lenders facing consequences because of how the IBC's related party definition is being applied.
Okay, now you have to give me the details. Give me an example of one of these cases where things went sideways for the lender.
All right, well, let's look at the IDBI trusteeship versus a Pinam Mukherjee case.
Okay.
In this case, you had a lender who had negotiated for some pretty standard rights, things like, appointing a director to the company's board, having vetoed power over some of the business plans, that kind of thing.
Right. Sounds pretty standard to me, just making sure they're in the loop, right?
Right, but the court, they saw those rights as evidence that the lender had too much control over the company, like they were calling the shots behind the scenes.
Interesting.
So they got slapped with that related party label, even though they argued that those rights were purely for protection.
Wow, so even trying to be a cautious lender can backfire in this system.
It definitely makes things tricky.
That's a tough spot to be in. So what can be done about this? What are the experts suggesting?
Well, the paper argues for a pretty reasonable solution, more clarity in the IBC.
Makes sense.
Lawmakers need to step in and make it crystal clear that standard lender protections, when used in good faith, don't automatically equal related party status. It's about distinguishing between genuine attempts to protect an investment and actually trying to control the company, right?
Right. Don't punish the careful ones. Makes you wonder if this lack of clarity might be making lenders hesitate to lend, especially to businesses that are already struggling.
That's a really important point, and it's a major concern that's being raised by a lot of experts. If lenders are afraid of being penalized for just trying to be prudent, they might think twice about lending, especially to companies that are already considered higher risk.
Yeah, it's like, why take the risk if you're going to get punished for it either way?
Exactly. And that could have a real impact on the economy.
Absolutely. This isn't just an abstract legal issue then, is it? It has the potential to affect access to credit and ultimately economic growth.
Exactly. It's all about understanding how these little nuances in the IBC can have real-world consequences.
Right, because at the end of the day, a healthy economy benefits everyone.
Exactly.
Now, we've established that the IDC casts quite a wide net when it comes to defining related parties. But what does that actually mean? What are the different categories of related parties under the IBC, and what makes them stand out?
Well, the IBC, it lays out several scenarios that could classify someone as a related party, and they fall into two main buckets.
Okay.
The first focuses on direct relationships with the company and its management. Think of it as anyone with their fingers on the pulse of the company's operations.
So we're talking about individuals in key management roles,
Right.
directors, partners, maybe even relatives of those in charge.
Exactly, you got it. It also covers those who advise or instruct the company's leadership, or those who have a significant say in the company's policies, even. It even includes situations where there's a sharing of managerial staff,
Interesting.
or like a deep exchange of technical information between the companies.
Okay, so it's not just about family ties or being on the payroll. It's about any kind of close relationship that could give someone, undue influence over the company's decisions.
Right. It's about who has the power to sway things, even indirectly.
Makes sense.
And that brings us to the second bucket of related parties under the IBC. This category delves into the corporate structure and voting rights.
Okay, this is where things get even more interesting, I think. So what kind of scenarios are we talking about here?
So imagine a company that's in trouble, right?
Right.
Under this category, the IBC, it looks at other companies or individuals who might have significant influence over the struggling company. For example, it considers entities where the struggling company's management also holds sway.
Okay, so like what? A parent company.
Yeah, like a holding company, a subsidiary, even an associate company. It's about understanding that web of relationships
Hmm.
and the potential control within that corporate structure.
So they're looking for companies that might be pulling the strings from behind the scenes, even if it's not immediately obvious.
Exactly. And it's not just about the structure either. Voting rights play a crucial role here, too.
Right, because ultimately that's what gives you power in a company.
Absolutely. The IBC pays close attention to who holds the power to make decisions for the company. If a person or another company holds more than 20% of the voting rights in the struggling company,
Okay.
either through direct ownership or through a voting agreement, that's a big red flag.
Right, it's like they have a front row seat to the company's decision-making process,
Mhm.
even if they're not directly in the driver's seat.
Precisely. And remember, being classified as a related party in any of these ways, it can have major consequences,
Hmm.
especially for lenders trying to navigate this whole insolvency process.
It seems like they're trying to cover all their bases. But I can also see how this could create a lot of gray areas.
Oh, absolutely.
And speaking of gray areas, there's another layer to this whole related party puzzle that we need to unpack. What happens when a debt is sold or assigned to a third party? Does the related party status stick with the debt itself, like a bad penny?
That's a fantastic question, and it's one that has sparked a lot of debate and head scratching in legal circles
Really, I can imagine.
because it gets complicated.
All right, so let's unravel that thread. What happens when a debt with that related party history changes hands? Does the new owner get caught in the crossfire, so to speak?
So here's the interesting part. The IBC itself, it doesn't provide a clear-cut answer about what happens to the related party classification when a debt is assigned to a third party. It's an area where the law is somewhat silent, which has led to, shall we say, creative interpretations.
So we're venturing into murky legal waters here. I knew we wouldn't be all straightforward.
Of course not.
So what are some of these different interpretations that are floating around out there?
Well, you've got some legal eagles who argue that the related party label, it's permanently attached to the debt itself no matter who holds it.
Oh, wow.
It's like a financial scarlet letter.
So even if an unrelated third party, someone with no prior connection to the struggling company, buys that debt, they inherit the related party status and all the potential downsides that come with it. That seems a bit harsh, doesn't it?
It can certainly feel that way, especially for those who had no part in the original, relationship between the lender and the struggling company. Proponents of this strict interpretation, though, they argue that it's necessary to prevent loopholes and really maintain the IBC's safeguards. They want to make sure that no one, regardless of their intentions, can just swoop in and exploit the system.
Right, so it's all about preventing those too good to be true deals that raise those red flags.
Exactly.
But surely there's another side to this argument, right? What about the folks who buy debt in good faith, unaware of this potential related party baggage?
You're absolutely right. There's another school of thought on this that focuses on the spirit of the law rather than just the letter of the law.
Okay.
They believe that if a related party debt is sold to a legitimate third party, someone who is genuinely unrelated to the struggling company, and they purchase the debt through a transparent above-board transaction, then that third party shouldn't be penalized.
So it's like the legal equivalent of no harm, no foul.
Yeah.
If someone buys debt without any malicious intent,
Mhm.
they shouldn't be punished for the sins of the previous owner.
Precisely. They argue that punishing bona fide third-party buyers, it could actually have a chilling effect on the debt market as a whole.
How so?
Well, think about it. If no one wants to touch debt that might come with this hidden related party landmine, it could make it much harder for struggling companies to find any financial lifelines at all.
That's a really good point. It's like a financial game of hot potato, and no one wants to be left holding the related party spud when the music stops.
Exactly. And that's where the courts come in to play referee.
Right, because someone has to make that call.
Exactly. They have to weigh the need to prevent manipulation with the potential impact on the debt market. And of course, the rights of those who had no part in that original related party relationship. It's a delicate balancing act, and the outcome can have significant implications for everyone involved.
Yeah, no pressure, right? So this is where those real-world cases you mentioned come into play, right? They show us how the courts are grappling with these different interpretations and trying to find that fair resolution.
You got it. Let's dive into a couple of these cases that illustrate these challenges.
Let's do it. Hit me with the legal drama.
All right, so one case that highlights this very issue is the City Securities and Financial Services versus Sudeep Bhattacharya case. This one went before the National Company Law Appellate Tribunal, or NCLA for short.
Okay, we're talking big leagues now.
Oh, yeah.
What happened in this case?
So this case involves City Securities, a major player in the financial world. They purchased a significant chunk of debt at a discount from a company that was considered a related party to the struggling company, RNEL, or Reliance Naval and Engineering Limited, to be exact.
Okay.
A lot of names to keep track of.
I know, right? So we've got City Securities, seemingly a third party with no dog in this fight,
Yeah.
but they're buying debt from a known related party. Sounds like a recipe for potential complications. What happened next?
Right. Did the court buy the whole innocent bystander argument?
Exactly.
Well, not so fast. The NCLPC, they took a good, hard look at the deal, especially the discounted price at which City Securities snagged that debt.
Right.
A discount, while common in these types of transactions, can sometimes raise eyebrows, right?
It's like getting a too-good-to-be-true deal on a used car.
Yeah.
There's probably a catch somewhere.
Exactly. And in this case, the NCLPC wasn't convinced that everything was on the up and up. They ultimately ruled against City Securities.
Oh, wow. Really?
Yeah, they concluded that the assignment of the debt wasn't done in good faith. They suggested it was a tactic by the original related party to kind of maintain a level of control over the insolvency process, even though they were technically out of the picture.
Wow. So even though City Securities wasn't directly related to the struggling company, the court saw through the transaction and classified them as a related party anyway. That's quite a precedent.
It is. It shows that courts are increasingly willing to kind of look beyond the surface of these deals and really scrutinize the intent behind them.
Yeah, they're not just going to take your word for it.
Exactly. They're going to follow the money.
Right. See where it leads. But this is just one case, though. Surely there are other examples where the courts have ruled differently.
Right. Oh, absolutely. There are always two sides to every coin.
Give me another case, but this time make it a plot twist.
All right, you're in luck because I've got just the case for you.
Okay.
Let's talk about Rare Reconstruction Ltd. versus Avishek Gupta. This case involved Rare Asset Reconstruction Limited, or Rare ARL. They were buying debt from another company called Shrey Equipment Finance Limited, or SEFL for short.
Okay. Keeping it straight.
Lots of acronyms. Now, here's where the plot thickens. SEFL had inherited this debt from a company that was, you guessed it, a related party to the struggling company in question, Sarga Hotel.
Okay, so we've got a similar setup to this city securities case. A company buying debt that's passed through the hands of a related party.
Hmm.
What made this case different? What made the NCLAT go, hold on a minute, something's not right here?
Well, in this case, the devil was in the details. The NCLET uncovered some interesting information that suggested that Cephal might have indirectly provided the funds for Rare ARL to buy the debt.
Ooh, so it's like Cephal was trying to have their cake and eat it too.
Yeah.
Getting rid of the debt on paper, but still potentially pulling the strings behind the scenes to influence the outcome of the insolvency process.
That's exactly what the NCLET suspected. Very sneaky. They concluded that the assignment wasn't a clean break and ruled that Rare ARL, the buyer, was indeed a related party to the struggling company, inheriting all the baggage that comes with it.
These cases are like mini dramas playing out in the financial
Oh,
world.
absolutely.
So a takeaway here is that the courts are really scrutinizing these debt assignments, especially when they involve related parties.
Absolutely. They're not messing around.
They're looking at the timing, the price, the relationships between all the players involved, trying to determine if the assignment is a legitimate business transaction or a sneaky way to game the system.
You got it. And this brings us to a landmark case that really shook things up in the world of IBC and related party classifications. The Phoenix Arc PVT Ltd versus Spade Financial Services Ltd case. This case was a real game changer.
Oh, I've heard whispers of this case. It's a big one, right?
Oh yeah, this is a big one.
Tell me everything.
All right, so this case tackled a crucial question that had been lingering in the air. When determining if a creditor is a related party, does the IBC only consider the present situation, or can they also look back in time to see if that creditor was ever related to the struggling company in the past?
Ooh, that's a huge distinction. It's like deciding if someone's past actions should follow them forever, even if they've moved on. So which way did the court swing?
The Supreme Court, in its wisdom, landed on what many consider a balanced approach.
Okay.
They stated that being a related party is judged in presenti, meaning they look at the situation as it stands at the time of the insolvency proceedings, not based on past relationships.
Okay, so a clean slate, a fresh start. A company that was once considered a related party could, in theory, shake off that label if the relationship has genuinely ended by the time insolvency proceedings begin.
Precisely. But, and you knew there was going to be a but, didn't you?
There's always a but, especially in the legal world. What's the catch?
The catch is that the Supreme Court, while acknowledging that relationships can change, also recognized that this in presenti approach could be open to manipulation.
Right, because what's to stop someone from just, like, quickly severing ties on paper, like a last-minute attempt to escape the related party label and gain an advantage in the insolvency proceedings?
Exactly. So the court, in its infinite wisdom, introduced a crucial caveat to prevent such shenanigans. They said that if a creditor's attempt to distance themselves from being a related party seems fishy, like a deliberate tactic to unfairly influence the insolvency proceedings, then the courts have the power to look past that facade and still classify them as a related party, past relationship, or no past relationship.
This is like they're saying, nice try, but we're not falling for it. We're washing you.
Exactly. The Phoenix Arc case was a game changer. It sent a clear message that while the IBC focuses on the present, it's not blind to the past.
Right.
If you're trying to pull a fast one, the courts have the power to hit rewind and expose your true colors.
I love it. So the Phoenix Arc case added a whole new layer of complexity to this already intricate issue. It's fascinating how the legal interpretation of these related party provisions continues to evolve,
Right.
through these court rulings and practical application.
It certainly does. And this brings us to another critical aspect of the IBC that has been a source of much debate and head-scratching: lender protections.
Okay.
We've talked about how those standard lender protections, things like appointing a director or having veto power, can sometimes be misinterpreted as signs of being a related party. But where does the IBC actually stand on this issue? And what are the potential implications for lenders and the insolvency process itself?
It's a tightrope walk, for sure. Lenders are trying to protect their investments, but they also don't want to trip any of those related party alarms in the process.
It's a delicate dance, and the music can change pretty quickly in the world of finance, especially when a company is on shaky ground. And that's why this next topic is so important: lender protections. We've talked about how those standard safeguards that lenders often put in place, things like appointing a director or having veto power, can sometimes be misinterpreted as signs of being a related party. But the million-dollar question is, What does the IBC actually say about these common lender protections? Does it offer any guidance, any carve-outs to reassure those lenders who are genuinely trying to be prudent, not puppet masters?
That's what I want to know. It seems like a real catch-22 for lenders. They're damned if they do, damned if they don't. So where does the IBC actually land on this issue?
Well, buckle up because this is where the road gets a little bumpy. The IBC, as it stands right now, it doesn't have specific crystal clear exemptions for those standard lender protections that we've been discussing. It's a bit of a gray area, which, as you can imagine, has led to a whole lot of legal debate and hand-wringing.
A gray area in the legal world, I'm shocked.
Mm-hmm.
So what are the different camps saying about this? What are the main arguments for and against having clearer guidelines on lender protections within the IBC?
So on one side of the ring, you've got those who believe that the IBC in its current form already provides sufficient breathing room for legitimate lender protections.
Okay.
They argue that the courts have shown that they can differentiate between actions taken in good faith to protect an investment and those sneaky maneuvers that are designed to exert control.
So they're saying trust the system, trust the judges. They'll be able to tell the good guys from the bad guys.
That's the gist of it. They point to cases like the Housing and Urban Development Corporation LTD case, where a lender had the right to appoint directors to the company's board, but they didn't actually have an active role in managing the company's day-to-day operations. The National Company Law Tribunal, the NCLT, in that case, didn't consider the lender a related party because they weren't calling the shots, just observing from the sidelines.
Okay, so 1 point for the trust the system team. But what about the other side of the argument? What are the concerns raised by those who believe the IBC needs to be more explicit about protecting those standard lender safeguards?
Right. So the other side of the coin, those pushing for a clearer carve-out for common lender protections, they argue that this current ambiguity, it's a recipe for uncertainty and risk. It's like asking lenders to sign a contract without knowing all the terms and conditions.
Right.
They fear that even those standard, widely accepted protections could be misinterpreted, potentially sidelining them in the insolvency process and leaving them with little recourse.
So it's a gamble they're not willing to take, especially in today's, volatile economic climate.
Exactly. And this apprehension, they argue, could have a ripple effect throughout the Indian economy.
How so?
Well, if lenders are hesitant to lend, especially to companies that are already facing financial headwinds, it could stifle growth and innovation.
That's a good point.
It's a tough balancing act.
It is.
On the one hand, you want to prevent abuse and make sure the insolvency process is fair for everyone involved. But on the other hand, you don't want to create so much red tape and uncertainty that it scares away lenders and hurts the very businesses the IBC is trying to protect.
Right. You don't want to solve one problem by creating another.
Exactly. It's a classic case of trying to find that sweet spot, that balance between protecting the integrity of the system and promoting a healthy, vibrant economy. So what's the solution? How do we bridge this divide? How do we provide some much-needed clarity on lender protections?
Yeah, lay it on me. What are the experts suggesting?
Well, many legal scholars and financial experts are calling for amendments to the IBC
Okay.
to include explicit language that safeguards those standard lender protections when they're used in good faith. It's about drawing a clear line in the sand and saying, look, these common safeguards, when used responsibly, they're not a problem. They don't automatically make you a related party, and they won't count against you.
Right. It seems like a pretty straightforward solution. Just spell it out, black and white, so everyone knows where they stand.
Exactly. It's about providing that certainty and predictability that both lenders and borrowers need to make informed decisions.
Makes sense to me.
Me.
But let's move on to another twist in this winding IBC saga. We've talked about how being labeled a related party can affect a lender's voting rights in the Committee of Creditors,
Right.
that powerful group that decides the fate of a struggling company.
Huge decisions.
But what about the actual money? How does the IBC handle the issue of recovering funds when a related party is involved? Do they get treated differently than other creditors?
The million-dollar question. Show me the money. The IBC doesn't beat around the bush when it comes to related parties and debt recovery.
Okay.
It aims to prevent those with close ties to a struggling company from getting preferential treatment, like a VIP pass to the front of the line during the resolution process.
So no more insider deals where a related party gets to, cash in their chips before everyone else.
That's the idea. The IBC is all about fairness and transparency. It wants to make sure that all creditors are treated equitably based on the nature of their claims and the company's assets, not based on who they know or how close they are to the company's inner circle.
Sounds fair to me. But does the IBC actually spell out how much a related party can recover compared to other creditors? Is there like a formula or a percentage they use?
The IDC isn't quite that cut and dry.
Okay.
It doesn't lay out a rigid formula for debt recovery. The specifics often depend on a whole cocktail of factors: the company's financial situation, the types of claims that are involved, the terms of any proposed resolution plan. It's a complex equation.
Right. There are a lot of moving parts.
Absolutely.
Okay, so it's not as simple as saying, related parties get this much and everyone else gets that much. There's more nuance to it, more room for interpretation.
Precisely. The IBC provides a framework for resolving these issues, and within that framework, creditors, guided by a resolution professional, and often through a whole lot of negotiation, try to hammer out a resolution plan that outlines how much each creditor will receive.
So it's like a financial puzzle, and everyone's trying to fit their pieces together in a way that's, fair and equitable.
That's a great way to put it. And the courts have made it clear that related parties might not necessarily get the same slice of the pie as other creditors, especially if their claims are deemed, less secure, or if they played a role in the company's financial downfall. It's all about holding everyone accountable and preventing those who contributed to the problem from unfairly benefiting from the solution.
So it's not just about who you are, but also about what you did or didn't do that landed the company in this mess in the first place.
You got it. And to illustrate this point, there's a landmark case, M.K. Rajagopalan versus Dr. Piryasamy Palani Gounder, which went all the way up to the Supreme Court. This case had a seismic impact on how we understand related party debt recovery under the IBC.
A Supreme Court case. Now you're speaking my language. Give me the rundown. What were the key issues at play, and what was the court's final verdict?
All right, so the M.K. Rajagopalan case centered around a crucial question. Do related parties automatically deserve the same level of debt recovery as other unrelated creditors just because they're creditors?
Good question.
Right. And the Supreme Court's answer was a resounding, not necessarily. They emphasized that the IBC doesn't mandate equal treatment in these situations. It's not a one-size-fits-all approach.
So the court essentially said, we're not going to reward bad behavior just because you happen to be a creditor. Actions have consequences.
That's the key takeaway from the M.K. Rajagopalan case. It set a powerful precedent that courts can and should differentiate between creditors based on their relationship with the company and their role in its financial distress.
Right, so it adds another layer of complexity to this whole related party issue.
Yeah.
But it also seems like a necessary one to, ensure fairness and prevent those who contributed to the problem from reaping the benefits of the solution.
Exactly. And that brings us to the final act in our deep dive into the IBC and its intricate world of related parties. Avoidance transactions.
Avoidance transactions. That sounds ominous. What are those all about?
Okay, so picture this. A company's heading towards insolvency. The writing's on the wall, right?
Right.
But in the months or even years leading up to their downfall, they start making some questionable moves with their assets, trying to shuffle things around.
Okay.
They might transfer valuable property to a related party at a bargain basement price, or they might suddenly decide to pay back a loan to a close associate, even though other creditors are knocking on their door, desperate for their dues.
It's like they're trying to hide the good silverware before the repo man shows up.
That's a great analogy. And the IBC has a name for these shady maneuvers: avoidance transactions.
Mm-hmm.
These are deals that are made with the intention to disadvantage some creditors or give preferential treatment to related parties when the company's collapse seems inevitable.
It's like they're trying to game the system, get ahead of the curve before the whole thing comes crashing down. So what can be done about it? Can the IBC do anything to reverse these transactions and make sure everyone gets a fair shake?
You bet it can. The IBC has some serious teeth when it comes to avoidance transactions.
Okay.
It can essentially hit the undo button on these shady deals, even if they happened before the company officially entered insolvency proceedings. It's like having a legal time machine to right past wrongs.
Okay, now you're talking my language.
Yeah.
Tell me more about this legal time machine. How far back can the IBC go? What's the statute of limitations on these avoidance transactions?
Well, this is where the plot thickens once again. The IBC actually has different look-back periods depending on whether the transaction involved a related party or an unrelated party. It's like having different levels of scrutiny depending on the relationship between the parties involved.
It's getting more and more intricate. So walk me through it. What are the different time frames we're talking about?
Okay, so for transactions with unrelated parties, Those who are essentially innocent bystanders in the company's financial drama, the IBC's look-back period is 1 year.
Okay.
So they can rewind the clock 1 year and examine any suspicious deals that went down during that time. But here's the kicker. For transactions involving related parties, those who might have had inside knowledge of the company's impending doom, that look-back period gets bumped up to 2 years.
Double the time, double the scrutiny. It seems like the IBC is sending a crystal clear message. If you're dealing with a related party in the shadow of insolvency, proceed with extreme caution. Those transactions will be under a microscope.
Precisely. The IBC recognizes that close relationships, while not inherently bad, can create opportunities for unfair advantage, especially when a company is circling the drain. And it's taking steps to level the playing field for all creditors, regardless of their relationship with the struggling company.
It's like having a financial watchdog with night vision goggles, keeping a close eye on those related party transactions, no matter how far back they go.
You got it. And that wraps up our deep dive into the fascinating, albeit complex world of the IBC and its related party provisions.
This has been an incredible journey. We've covered so much ground, from dissecting the definition of a related party to exploring how these classifications can impact lenders, debt recovery, and even the validity of past transactions. Who knew the world of insolvency law could be so riveting?
It's certainly not your typical dinner table conversation.
No.
But it's an area of law with huge real-world implications impacting businesses, investors, and the overall economy.
Absolutely. It just goes to show that knowledge is power. The more you understand these intricate legal framework, the better equipped you are to navigate this complex world of finance and come out on top.
Couldn't agree more.
Well, that's all the time we have for today's deep dive. We hope you found this episode informative and, dare I say, entertaining.
Until next time, stay curious.
And remember, when it comes to the IBC and its related party provisions, always read the fine print.